The challenge in the present appeal is to an order passed by the Division Bench of the Kerala High Court of 19/7/2019, whereby it was held that Section 14 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, mandating the district magistrate to deliver possession of a secured asset within 30 days, extendable to an aggregate of 60 days upon reasons recorded in writing, is a directory provision. The High Court held as under. The primary question in these writ petitions, namely whether the time limits in Section 14 of the Surface Act are mandatory or directory, should be answered in light of the principles enumerated above. As stated above, the object and purpose of the said time limit is to ensure that such applications are decided expeditiously so as to enable secured creditors to take physical possession quickly and realize their dues. Moreover, as stated earlier, the consequences of non-compliance with the time limit are not specified, and the secutor thereof would be that the district collector / district magistrate concerned would not be divested of jurisdiction upon expiry of the time limit. In this connection, it is also pertinent to bear in mind that if the consequences of non-compliance test is applied, the borrower, guarantor, or lessee, as the case may be, is not adversely affected or prejudiced in any manner, whether such applications are decided in 60, 70, or 80 days. On the other hand, the secured creditor is adversely affected if the provision is construed as mandatory and not directory, in as much as it would delay the process of taking physical possession of assets instead of expediting such process by entailing the filling of another application for such purpose. For all these reasons, the time limit stipulation in the amended Section 14 of the Surface Act is directory and not mandatory. The High Court examined Section 14 of the Act as amended, which reads thus: 14. Chief Metropolitan Magistrate or District Magistrate to assist secured creditor in taking possession of secured asset. Provided further that on receipt of the affidavit from the authorized officer, the district magistrate or the chief metropolitan magistrate, as the case may be, shall, after satisfying the contents of the affidavit, pass suitable orders for the purpose of taking possession of the secured asset within a period of 30 days from the date of application. Provided also that if no order is passed by the chief metropolitan magistrate or district magistrate within the said period of 30 days for reasons beyond his control, he may, after recording reasons in writing for the same, pass the order within such period, not exceeding in the aggregate 60 days. The Act was enacted in the year 2002 for reasons that the legal framework relating to commercial transactions had not kept pace with the changing commercial practices. Further, financial sector reforms resulted in a slow pace of recovery of defaulting loans and mounting level of non-performing assets of banking and financial institutions. The objectives behind the Act recognized that, unlike international banks and financial institutions in India did not have power to take possession of securities and sell them. The provisions of the Act were upheld by this court except that of subsection 2 of section 17, which provided that the Debt Recovery Tribunal shall not entertain an appeal preferred by a borrower unless 75% of the amount claimed has been deposited before it. Thereafter, the question as to whether the withdrawal of an application filed under the Recovery of Debts Due to Banks and Financial Institutions Act 1993 is a condition precedent to take recourse to the Act was examined by this court. This court observed that when civil courts failed to expeditiously decide suits filed by the banks, the DRT Act was enacted. However, it did not provide for assignment of debts to securitization companies. The act, which was enacted thereafter in 2002, sought to further empower the banks and facilitate the recovery of debt. It proceeded on the basis that once the liability of a borrower to repay crystallizes, it becomes due, and that on account of delay, the account of such borrower becomes substandard and non-performing. Stop.